don't have a gavel, but we'll just get started. Yeah, right. So we're here for the May 15th Policy Committee meeting. We have quite a full agenda for tonight. First blush, it's not that many policies, but these are, a lot of the policies are consolidating policies that appeared either in 2 or 3 times in our previous policy book. So there was a lot to review for us, and I think that we'll have some good discussions on these. We will start with policy 350, which is prohibited controlled substance, drug, and alcohol use and possession. This is going to be a proposed new policy, and it's consolidating 2 or 3 of our old policies. It's consolidating 352 alcohol, 353 testing requirements for alcohol and controlled substances, and 810.1 testing requirements for alcohol and controlled substances.
And if I could just add, as it all pertains to employees, that's the category of policy work.
It's really okay. It's okay. I think the claps worked. Yes, so this is all of those previous categories were our different classes for employees and the policies that had to do with each one of our classes of employees, and now we're going to consolidate them into one. So Justin, do you want to give some background on how you put together the consolidated policy?
Sure. So in working through the 300 series, as we've been doing over the last couple meetings, we identified the 3 policies that you referenced, as well as 351, which was our drug-free workplace. I'll call it a policy, but it was really just a notice or notification that is part of our federal grant obligations. So what we did was we reorganized really all 4 of those together and made uniform definitions throughout. So we moved all the definitions from all of them into one place. We added a section on reasonable suspicion for employees under certain circumstances into the policy itself of 350. The 810.1 was drug testing for driver employees. Mm-hmm. So that really was then just turned into an AR that's going to be attached as now the 350 AR1. And that's really it. There was some repetitive language with regard to symptoms of someone being under the influence, so we tried to remove any duplicative language and incorporate it all in the same place under the reasonable suspicion testing definition as it relates to under the influence. Mm-hmm. But that's really it.
Okay. So those this is one of the ones that didn't list the old policies ahead of it, but the previous policies were in substance similar to what we have here. This is sort of just a reflection of consolidating them, and
it's more for efficiency purposes. Yeah. That's right.
Okay. Yeah. I just have a couple questions on the policy first. So I think I saw it in other places, and you know what? I think I saw it in the AR when you're talking about drivers under the substance. But for controlled substances and drugs, do we need to reference any sort of medical THC or other like medical marijuana type prescriptions? Should there be something there?
Are we looking at the AR or the actual policy?
I'm looking at the policy here first.
Got it.
I think there was a reference to it, I think in the AR somewhere.
Okay.
And so that's why I said I think I saw it in here somewhere, okay. But I didn't see it in the policy itself.
Gotcha. All right.
Yeah, I had the same question.
So we can. The answer is we can. A couple years ago, there was supposed to be guidance issued from the state, which never was. Okay. So we do have obviously the medical marijuana statute in Pennsylvania.
Right.
Because we are also a federal fund recipient, and marijuana is still controlled substance under that scheme.
Yeah.
There's a little bit of disagreement, I'll say.
Tension, yeah.
Between the two schemes. So where this is generally kind of falling is, so if someone has a prescription under state law and state code, we would potentially be analyzing that on a case-by-case basis. I don't want to speak for Executive
Yeah.
Mundos or the HR office, but at the same time, you still can't be utilizing it or in
Yeah.
possession of it on school property.
Okay.
And you can't be under the influence of it to the point where it's impacting the employee's ability to perform their job.
Yeah, I wonder if we should put in something, in here, sort of like that. You know, if you have a subscription, or, oh my gosh, I keep saying subscription, a prescription from your doctor for this, for one of those types of, prescribed drugs, that would be something you need to bring to the administration. But regardless, all of these under the influence definitions nonetheless apply, just like it would if you had, you know, any other prescription that would, you know, impair your abilities, right? I don't know if there's something else that we can just reference in here, because that's when I'm reading it. If I am someone who has that type of prescription, let's say for anxiety or something, I'm wondering where do I fall and what am I supposed to do?
Sure.
So I guess I have the same question, but also as it relates to alcohol. And maybe it would be helpful, I think, if we could just look at a few of them, because if alcohol references a beverage, there's also different types of medication. So is it appropriate to have a level or amount if we're talking about alcohol and or controlled substance?
This is definitely going to come up in the AR, because the .02 and the .04 and the .01 in here, and I'm like, what is happening? So I think we're going to talk about, yes, but we should talk about it now too, and it's definitely going to come up.
And I
for
guess
the AR.
because if we say shall mean any beverage, so I also wouldn't want someone that does have a prescription for a liquid medication, but if that's going to impact their ability to teach, they're intoxicated, medication or not, I'm sure they're not supposed to be working.
Yeah, right.
So I think that a beverage suggests that it's only going to be a beverage where it could actually be other things, other liquid forms that could contain alcohol.
Yeah, that's a good point. That the definition of alcohol looks like beverage is a prerequisite to fall under that definition. And so you're thinking we need to expand that.
Yeah.
Yeah.
And that definition was carried over from your prior version of this, and I don't have it in front of me exactly, but it was quite old.
Yeah.
So
Yeah, maybe there's an updated one
we
from
can,
PSBA
we can
that we
take,
can use.
we can take a look.
Certainly, at the very least, it should say, shall mean any beverage or other substance containing alcohol. And who knows what people are putting alcohol in
Right.
these days.
And I'm
As
not,
long as we're talking about the levels, I just found it kind of arbitrary, .0.
In the AR, it was that was one
Yeah.
of my questions too. I'm like, when and where and why? Are
Also-
these codes?
For the drivers, that's all
That's what I figured.
statutory.
for the drivers.
The drivers, that's all statutory. And
Why is the .1 not .08? Because that's the Pennsylvania back limit.
Oh, didn't know.
why
It
is,
says .1, they'll be referred to police. Let's see, where is it?
Where,
In the
are we in
AR?
the AR?
I'm sorry, it's in the AR. I thought we were skipping ahead to the.
No, we're not, but-
Okay, never mind.
We'll definitely come to that. And that's what I assumed when I was going over the AR, was this has to be code, because otherwise it seems very arbitrary and confusing.
I'll find the .1.
And as I know we're kind of going down, but I have a question about the purpose before we get too far
Yeah.
into it.
Go ahead.
Oh, so my question is that I'm unclear as to what this means. It's the first 1, 2, 3.5, might as well say 4 lines is one sentence. And so if it could just be cleaner and I think clear, concise, straight to the point. I'm not sure if there's other recommendations, but I mean, to say that it's a serious problem and leads to negative physical, social implications, like, I would like to see it something that talks about how it impacts their ability to act in their role as teacher, administrator, employee, something as it relates to their performance. Certainly, maybe a second sentence could reflect the social implications for the school community. I know that we have a code of ethics and things of that nature, but the first sentence should just be very clear and solid for me.
Certainly breaking it up into 2 sentences.
Maybe 3, I don't know.
Yeah. I mean, yeah, I think, after, on the second line where it says entire school community, I think you can have the first sentence be there, and then strike the part about the district is concerned about, and just say problems may be caused by drug and alcohol use by district employees, especially as that use relates to employees' health, safety, efficiency, and productivity. Yeah, I mean, you can say the employee and community health, or student, or whomever, but obviously that affects a lot more than themselves. No, do you think we should add more than that too?
I don't think so. I think if it gets too wordy, then
Yeah.
we lose people.
Yeah, I agree. Okay, so I think tighten up the purpose. Look into whether PSBA has a better definition of alcohol. I would think maybe they have something about controlled substances and drugs too. And if they mention anything about medical marijuana or THC, I honestly don't know the right term. So, sorry everyone, but.
My recollection is that it talks about what it's not,
Yeah,
rather than affirmatively taking the position on where it falls.
yeah.
But
I think just having, maybe even as part of the guidelines, put prohibition of alcohol possession and use by drug-free and alcohol-free workplace. I think in here, we put something about our general practice that already exists, which is, if a staff member has a prescription, to raise that with the district, right? And notify the district, and that will be held, or that will be considered on a case-by-case basis, or whatever the policy actually is.
I think it's important because I think the AR, I know we're not to the AR yet, but I think, doesn't it prescribe a certain percent or certain level random test?
So just to clarify for everyone, the AR, 350 AR1 only pertains to drivers.
Bus drivers.
Drivers.
Yeah.
Oh.
And drivers really are a very specific
Yeah.
subset of the employee population that have different guidelines than everybody else. I mean, there is some overlap in that there can be reasonable suspicion testing for drivers, kind of upon interaction, or someone noticing behavior. But then drivers also have other types of testing and specific standards related to the levels that other people may not, and that's just coming from federal regulations.
Okay. So drivers are the only ones subjected to random or testing? Okay.
So, looking at, let's finish with the first page. Any other questions, through the drug and alcohol-free workplace
Through the drug.
definition? I have a comment about the reasonable suspicion testing definition, so.
So just for clarification, the covered school bus driver, that's a very specific defined term. We can't do anything with it, right? Okay.
Yes.
Okay. So what does it mean by I just have a question then. The phrase includes, what phrase? Undercover school bus driver, the second sentence.
Referring to covered school bus driver.
Okay.
Actually, we can write this definition.
Yeah, that would be helpful because I'm looking for another phrase.
Yeah.
And what would be considered a casual, intermittent, or occasional individuals? Casually operate our buses. I'm just curious.
Sure, and it's.
Something from an old
It's-
time,
and
whenever
it's-
they created this.
It's one of,
Okay.
we've hit this a couple times over the years in different contexts, and it really just, it's a definition that was
Okay.
directly copied and pasted into the,
It's just old.
The body of the
They don't
policy.
update their policies like we update ours.
All right. I didn't know if we had casual drivers floating around.
we don't, we could also remove it.
Yeah,
I think we should just make that clear because that could mean,
Take out casual.
you know, like an employee. I would like some reference of someone that
I think it's a distinction, because what precedes it is including full-time regularly employed individuals, so it's like a part-time bus driver, but we could just remove that and say part-time bus,
And
part-time driver.
yeah.
Yeah, part-time driver. I'm also thinking about just for insurance purposes, if we ever, you know, have some sort of incident from a casual driver, would our, in all seriousness, is that something that our insurance would cover? Okay.
Occasional individuals. Such an odd phrase.
Yes. Okay. All right, I'm okay with that, if we can just adjust those words there.
Looking at the definition reasonable suspicion testing, I'm fine with what it says. It's just that elsewhere, we just use reasonable suspicion. And so I just wonder if we should just have the defined term be reasonable suspicion, instead of reasonable suspicion testing. Because like, under reasonable suspicion testing, we have reasonable suspicion in bold and saying as herein defined. So, okay, that's okay? All right.
I think sorry, I need to turn this on. I think the goal, as I remember this, was to indicate that testing may become a part of it and to just bold it up front, so it's not.
Yeah.
It's not a hide the ball situation, but
I think it's fine with like, because the determination of reasonable suspicion exists to require an employee to undergo testing. So I think it's right there.
read the first sentence, it's right.
Yeah, and then it's its whole section too. Reasonable suspicion testing is a section, so I think we're fine on that.
Is it repetitive? I find it repetitive that under the influence has, you know, has bloodshot eyes like a coordination ball, and then under reasonable suspicion it also has many of the same things. I don't know. Maybe that's okay.
I think it's okay,
Okay.
just because we want to be clear that we're allowed to do a lot of the, like,
Right, okay.
make clear what counts as reasonable suspicion since we're forcing testing. And then to be clear, number 17, saying that you can test for reasonable suspicion if test results indicate evidence. I was a little bit confused by this at first, but then I reread it like 5 times. And I think that so I have a question, is this in the right place? But I think it is in the right place because it's saying that the testing can be evidence that more testing is needed. Is that right?
Are we looking at 17?
Yeah, number 17.
The way I read that is, I guess if the test happens within a certain time period, you would back calculate or something, and they would have been driving, right? Isn't that what that's trying to cover?
So since these are factors that could indicate someone being under the influence, it's essentially saying that the test result itself.
Okay. You know, I think this might be solved by not having testing within the reasonable suspicion definition, you know, because it was like the
Sure.
testing for the testing. So I was getting a little bit confused, but that's helpful. Those are all of my comments on the policy, so certainly if anyone else has comments on the policy before we move on to the AR.
It's just our first reading, so
Yeah,
I'm okay. I don't have anything additional right now.
Do we solve the medicinal marijuana?
I think Justin is gonna look and see if PSBA says anything about it. And then I think what my suggestion was just to add a statement about it in, under the drug and alcohol-free workplace. So
Okay.
add a statement there that aligns with what our practice is.
Okay.
And in that same statement, we'll address
Let's see.
both medications that include some alcohol component as well as other prescription drugs or medications.
You may have a prescription, yeah.
Okay.
Yeah, that makes sense. They are, all the numbers here. So at first I was thinking, well, why would this definition appear twice? But now understanding that this entire AR is because of this covered school bus driver, I think it's actually okay to repeat it again here. Because obviously it's in the policy as well, but this entire AR is about the school bus drivers, so I think it's okay that it also appears in the policy.
Get rid of casual.
Yeah, right, just match it, right. We'll get rid of, so just match this to the other one.
So the back of point 1 is referred to in 3.5, I think. It's struck out, but Article 3. So the blood alcohol result of 0.1 or greater, should that be consistent with the current Pennsylvania back limit? Let me see if I can describe where it is.
Where are you?
It's under Article 3, it's down.
Oh, okay.
It's under consequences for drivers engaging, and then, that's where it says a covered school bus driver who's found to be between
Oh.
0.02 but less than 0.04, and then what are the consequences? And then under 3.4, it says, 3.5 that struck out, where alcohol testing shows a concentration of 0.1 or greater after driver's been driving, the matter shall be turned over to the police. Should that be, the Pennsylvania limit is 0.08.
Yeah, I had questions about all of the numbers in here, but yeah, we can start with that one, because
Do you see where it is, Mr. Barba?
Yes. So all of these are directly from the statute. So, this was formerly your 810.1. All that we really did was clean up the language and move that definition of covered school bus driver to the top, for the sake of kind of reader continuity. But other than that, all of this,
I guess the question is though, can we refer them to the police if it's above 0.08? Like, do we have to wait until it's 0.1 because that's what the statute says? Is that like what your question is?
Yeah, my question is just whether this policy is aligned with the current Pennsylvania state law regarding,
so 3.5.
this 0.1 doesn't mean anything anymore, right?
Yeah, I don't think so. Did it used to?
I think it used to be point.
When was it 0.1?
I don't know.
No, it is 0.08.
I feel like as long as I've been driving, it's been 0.08, but I don't know. Maybe, I don't know.
Let's just.
Yeah, I'll take
But when was the policy written too? Oh, we don't have that.
I'll have to take a look at this. I want to make sure.
So 2003, Pennsylvania changed its legal limit from 0.1 to 0.08.
I want to make sure that that's not a typo, and that it's not 0.01.
No, I think it's 0.1 because then we're saying that this is like you are now illegally operating a motor vehicle. Because we wouldn't turn someone over to the police at 0.01, right?
Well, they're driving a school bus.
I understand, but then, but my question was, over here, go to number 1. No covered school bus driver shall report for duty within 4 hours after using alcohol. So while having an alcohol concentration of 0.04 or greater. So I'm like, why not 0? Like, if it was really, we're gonna report you to the police at .01, this should be .01, and I'm fine with that, to be clear. But that's, we have a bunch of different provisions, .04 here, in what used to be number 3.2, it's .02. A concentration of .02, but less than .04 shall be suspended. So, I mean, there's all these, like, different specific, whatever the test
Yeah.
shows, but I
Yeah.
I agree. I don't think any bus driver should be working with
Yeah.
more than a .01,
Yeah.
to be clear.
No, and I'm sorry, Dr. Sutton, I think I misunderstood the question. I'll take a look at it. I'm inclined to say, yes, we can still make a report at .08. But let me take a look at
Put
this.
the number in it.
Yeah.
08.
I want to take
But I guess,
a look at this.
yeah, but I agree with Antoinette that, I'm sort of zero tolerance.
Yeah, right,
Sure.
for bus drivers and alcohol limits? I mean, yeah.
Where do you see, I'm sorry, I missed where you saw that. So they can come to duty?
So in the very first employee prohibitions, it says, on the very first section, it used to be 1.1, no covered school bus driver shall report for duty or remain on duty,
Oh.
Romanet 1, while having an alcohol concentration of .04 or greater. Like, can we just make that .01?
I'm gonna have to take a look.
I'm not
Okay.
a
I'm gonna have to take a look at
physician,
that.
so I don't know what.
I know, that's what I'm saying, I don't know,
I'm thinking about, if you look at the last one, it says within 4 hours after using alcohol. I don't know how long does it take for alcohol to escape your system.
that
So-
depends on your muscle mass.
Right, but I'm thinking that's why.
Yeah, your
but-
body weight,
but-
I mean.
But my point is that I wonder if that's the reason why that can't be .01. Because it could be 4 hours for someone else, but it could also be 8 hours. That would change whatever their alcohol level is.
Yeah.
So also, just gonna throw this out there, and Dr. Romanos, feel free to hop in on this. When somebody shows up and there's a sign of it or a smell of it or anything, they're not getting
the
into the
school
vehicle
bus.
to drive, because then we're gonna go and figure out what
Right,
the actual number is, but by that point, we've probably already pulled them off the
Yeah,
vehicle.
I see what you're saying.
So,
Like, how would you know what the number is?
which is where the whole premise of the reasonable suspicion testing based
Right.
on the actions and behaviors and things like that comes.
But I guess if, okay, so, but if they do show up and show they're symptomatic and you test them and they're .039, did they technically have it violated?
yeah, they have violated this one, when they get suspended because they're between .02 and .04.
I see.
That's a suspension for 24
Well,
hours.
and I think that's actually a really good point for the committee to consider, is it's not as if somebody, there's usually something that happens that triggers the test, and the test is done after the fact that then relates back to what the individual presumably was, what their levels were at the time of. And it's not necessarily like somebody's walking in and it's like, okay, take the test before you get on the bus or the, in the vehicle. So, but let me take a look at because those numbers do come out of federal regulation. So it's one of those things where we may be stuck with the numbers themselves, but nonetheless, we do have leeway built in, through other policies and administrative regulations to promote safety and prevent something from happening that we don't want to happen.
Yeah, okay. I think we need more information on this one.
Sure.
Because I'd like to know sort of what we can and cannot change, if anything. And for the numbers, and then if we're dissatisfied with what the numbers or what we're required to have for the numbers, is there something else that we can do to just put in that, make it clear that, you're not getting on our bus?
Sure. Well, and the other thing, again, remember you're tying, there's kind of the connection between the exhibited behavior and what the actual number itself in a test may be, but the standard is really the observations of how an individual is behaving.
Yeah.
So while somebody may end up going for a test later on and it's at a level that may not be criminal, there's still an opportunity, if something is showing up and based on how somebody's acting, that there may be some type of action up to, disciplinary or beyond that, depending on how they're behaving in the interaction is.
And I think that's definitely the concern for me is, thank goodness, we're not letting them get on our bus. But, they've exhibited this behavior, maybe they get a test that comes back at a certain level, and then are they getting on our bus 3 days from now? There's a underlying issue there, and that needs to be resolved, and does our policy allow us to do that?
You have to press it gently.
Gently.
There you go.
So obviously, that would be a serious concern for us
Yeah.
if we had anyone that would be a reasonable suspicion. Just so you know, like the protocol is I'm contacted immediately and I immediately go down to wherever the individual would be and then do the assessment right there. And obviously, we're talking about a school bus driver here, so we would have to follow the proper channels, but that would be obviously a serious concern for us. So it wouldn't just be as simple as going back and putting them back on the bus.
Right. And I just want to make sure that the district has what it needs to make
Right.
sure that, anything going forward, any disciplinary action or anything going forward, that they
Right.
have that, authority, right? To make sure going forward that this, maybe it was a one-off, but maybe we need to make sure that this person should either not be working here anymore or needs to be reassigned or something else. Yeah. Okay.
And they do,
Yeah.
They do it in transportation. You do the random.
Yeah, we do
checks.
random testing actually at transportation.
That was something else that we can talk about now, because the random testing section says that it could be conducted by the federal government. And my question was, well, do we ever do random testing? And if so, we should put that in here.
Yes, we have a company that does the random testing.
Okay, so we should add in here that from time to time, the district or the federal government, I assume that comes from code and they're allowed to do that. But make sure that we give ourselves the ability to do that too, that the random testing could just be done by the district. Okay. Also just making sure that throughout the definition is sometimes school bus driver and other times just bus driver. So that just needs to be consistent. Okay. But I think we'll bring this one back because we want to know
Lots of things.
the laws about it. Yeah, right, lots of things. Okay. So we'll just hold on both of those since that go together. Okay, the next one we're gonna go over is, policy 301, which is a proposed new policy creating a position. And it was formerly 3 separate policies, found under 301, 401, and 501 for the same reason that we discussed before, that our policy book was split up by the class of employee. So, the majority of the policy that's shown is the old policy, which I don't think we need to talk about. So moving to the new combined policy.
Starts on the back of the second page if you have.
Yeah. You'll see all the green
Okay.
Yeah, I'm going through
There
it.
we go, okay.
right there. Yep. So if anyone has any question about that. I didn't have too many comments on the policy. But is the thinking that, at the end of our audit, we'll just have one section on employees?
Yes.
Okay.
So PSBA started moving toward that maybe 3 to 4 years ago. And some districts have, some districts haven't, depending on, a lot of it's maybe driven potentially by their collective bargaining agreements, distinctions amongst employee groups. At the same time, even the districts that have maintained separate sections, there is a lot of overlap for things like this, creating a position.
Well,
Some of the others we'll talk about tonight too.
I really like this approach because it makes it so that it is, the policies are equal, and where there do need to be differences, you know, we can put that in here, right? And they can be noted, for different class of employees. We also have throughout, I think, all of these references to the collective bargaining agreements and contracts and things like that. And so I think this is great because it's just one place to look, and making sure that our policies that are intended to be the same for all staff are actually the same. Yeah, exactly.
Yeah.
So I have a question about under guidelines number 1. A position description that is clearly descriptive. I think that it seems a little, yeah.
Yeah, that clearly identifies the duties, yeah.
Well, a clear description of the duties for which the positions were created would be, I guess, the clear.
I think they're using a position description as like a noun.
Oh,
You know what I mean?
seriously. Okay.
I feel like identifies.
I like identifies too.
A title that conforms to the appropriate certificate. Let me clarify what that is intended to mean.
I think that's, isn't it like?
George.
Oh, sorry.
Yeah, depending on the individual and what type of, you know, certification they have, you know, you have your middle school teachers and they have, you know, 6 through, bless you. You know, elementary has, you know, pre-K through 4, and just depending on their certification and what they have. So that's why it's important that we have that information in there.
Principal, you're gonna call for principal.
Yeah, yep.
Oh, okay, yeah.
Supervisors, you know, special education.
Okay. Okay. Thank you. Bless you.
So in the paragraph that starts in the exercise of its authority to create new positions, the board shall give primary consideration to the following. Number 3 says special needs of students. And I just wonder if we wanted to reword that because it sounds maybe like it's just talking about special needs. And I think that we mean something more broad than that.
Needs of all.
The needs of all students. That's what I was thinking too. Any comments on this one?
Yeah, I don't really have any.
Is it worth us having under the same spot, the exercise, anything that speaks to, I don't know if it's going to be district goals or any type of achievement or things that we must accomplish, something that is in line with what we do in our district that's important to us? I mean, the goal of all of this is related to education, so.
Like under that paragraph, you mean?
Something, because we're creating new positions for all of these things, but all of these things have one, I feel like, ultimate goal that I feel like we're not necessarily speaking to. I don't know, is that something that
Or would
we?
you like to add a number 4 under the recommendations for continuing the year where additional positions shall include, and number 4, some wording that like the position or supports.
Condition.
Mission of the
Yeah.
district. I like that a lot. Oh, that one was painless. I'm gonna put this in this pile over here. We're gonna move that one forward. Yeah,
Remove this one
for a first
for
reading.
first reading.
I think the 5th.
I think
Yeah.
yeah,
I
because the
don't-
22nd, we'd have to have it ready.
There's no
tomorrow.
rush. I think yeah. Okay, so the next policy that we're going to review is policy 308. It's a proposed new policy consolidating, three separate policies, 308, 408, and 508 for employment contract and board resolution. So these were previously found in our different sections of the book. Okay, and again, we have a bunch of old policies. So there's no green on this one, but does that mean anything to us, or it just didn't show up?
No green, no line.
It does. Here's what it means. So we really didn't add anything other than that subsection on resignations.
Okay,
Everything else came from one of the other three, and the reason why is, generally speaking, professional employees in the Commonwealth of Pennsylvania have to have a written contract.
okay,
Then you have the individual contracts. A lot of times, central cabinet administrators have those. But not all of, this is one where not all the language necessarily applies to all of the personnel groups.
yeah,
So there's kind of broad language throughout, but it's only going to be applicable to certain groups in certain times. Same thing with, like in the guidelines, you'll see professional and temporary professional employees. It speaks to the contract. That was taken directly from one of the prior existing, I think it was in 408. But so really the only new addition, I apologize for not, I just forgot to put the track changes on,
It's
is
okay.
the resignations subheading at the bottom.
okay. So, yeah, I had a question, because looking at the guidelines, and that goes through the different types of employees, does the district have any at-will employees? Or are all of our employees have some sort of contract or agreement?
All of our employees have a contracting agreement. The only two that would not be, would be Chartwells, but we have a contract with
Yeah,
them.
that's a different.
That's
Right, no,
different,
they're not at
yeah.
will. Yeah, right, okay, that was my question. 'Cause then I would just wanted to make sure that we had something in here about at-will employees, but if we don't have any, then
Yeah.
we shouldn't have it in, okay. But our food services employees, they're employed by Chartwells, right?
No.
No, there are employees,
Oh,
but
Should we say?
no, they're the supervisors there.
Not part of bargaining.
Yeah, but,
I just want to make sure we're
Yeah.
capturing what you.
Yeah, well, then I'm
Is-
just wondering if we should-
Everybody covered here.
right,
Yeah.
that's what I'm saying, and so maybe we have something or other at-will employees as needed. Like, it doesn't have to spell out who they are.
right.
But if we
Good
just
idea.
say, maybe number 4, other at-will employees as needed, right?
That's a good point, yeah.
So maybe I would say something like, yeah, you'll have to make it conform to like the other, yeah, but that was all. Okay. I didn't have any other comments on this one.
I don't either.
I'm good.
Okay,
So we can miss that one first.
yeah. Moving right along here. The next policy will be proposed policy 309, and it is consolidating policies 309, 409, and 509 about assignment and transfer of employees. So let's see here to get to. Yeah, this was a really short one. I think there was, yeah, the AR goes with it, right?
We did create a new AR.
Under, I guess the old I'm looking at the old, I'm on I'm looking
Yeah,
at the
you
old.
just
yeah, I'm
scroll
looking-
down to the new combined.
Yeah, see, under the old 309, delegation of responsibility has a bunch of decision criteria. Did that get put into the AR?
That was moved into the AR, Dr. Sutton.
Yeah, and then, so now it's under general guidelines in the AR.
Okay, thank you. Yeah, it's pretty short.
Yeah, this one is short. I didn't have any comments on either, actually.
The one point I did, is it okay to transition into discussing the AR? The one point I did want to make the committee aware of is that Dr. Raimundos and I spoke earlier in the week. There's a subheading with regard to probationary classified employees. We're actually going to delete that because after speaking, that status is dictated by the CBA anyway, so it's unnecessary to have in the AR.
And so, since it's in the CBA, it could change, right? And we don't want to, codify something that could change. Okay, that sounds good. Then just make sure you take that out before the first reading of these.
Yes. Oh, and there is one other point, I'm sorry.
No problem.
So we're also going to add in the general guidelines section, so it's initially visible to the reader, that even though we have it a little further down, that the conditions of any collective bargaining agreement or individual employment contract are going to control. So that's going to be added as a number 8 at the top of the general guidelines.
The rate at the bottom of the general guidelines.
I'm sorry, number 8 at the bottom of the general guidelines, which are at the top of the AR.
Okay, yeah. Collective bargaining agreement. Yeah, that makes sense. Okay. So the next policy we're going to take a look at also has an AR. This one is a proposed new consolidated policy about tobacco products. This will be policy 323, and it consolidates policies 323, 423, and 523. It was last revised in 1997, which I'd just like to point out.
You did, didn't you?
Sorry, Dr. Rishi.
We had like.
When I see the 90s, I'm like, I gotta say something. The Spice Girls were on tour.
Not much has changed.
No, I think that was 96. Okay, anyway. So this is where I had seen the Medical Marijuana Act referenced, which I thought was a good reference here. But so that's, when I said I had seen it earlier, I think this was the reference that I was talking about. And I appreciate that we are updating this, obviously, because a lot has changed since 1997 about smoking. And so including Juul, references Juul to e-cigarettes, et cetera, is really important clarification. So the only thing is with so under term tobacco product does not include the following. It says that it does not include the medical, something licensed with the Medical Marijuana Act. But then it says guidance issued by the PA Department of Health directs schools to prohibit possession of any form of medical marijuana by students at any time on school property. I totally understand that, and not only do I agree, but it's the law. But I just wonder if it fits there.
So this was actually something that Dr. Raimundos and I spoke about earlier this week too.
Okay.
We're going to circle back on this before this is advanced to clean it up. That addition is based primarily on some PSBA recommended language. They actually just updated that model policy again, I want to say toward the end of last year.
Okay.
And so there's also, you'll see in the AR language, there's kind of this overlap where it starts talking about students a little bit.
Right, I'm like, we're in the
So
employee.
we're
part of
we're gonna clean that up.
Okay.
Moving forward.
I guess, like, I would think it would be fine to have the term tobacco product does not include this. And then to have some sort of disclaimer saying, regardless of the above, students can still not have it. Do you know what I mean? Just like, so if we're gonna put it in there, maybe you'll do this, just separate it. It just doesn't make any sense as part of this
I don't,
definition.
I don't think, in my personal opinion, since this is, and really because we're now streamlining this to be just a single chapter for employees, it probably doesn't make any sense to
Yeah.
have this. I mean, there are student sections that
Right,
speak to.
that will speak to this. Yeah, it really doesn't, it took, I was like, was that a typo? Like, did they mean staff? But then I was like, but the first sentence says that.
No, it's-
This is very confusing. Okay. Okay, and then I think it says this continuing on that same paragraph, that the exception shall be governed by the board policies relating to controlled substances and drug-free workplaces. And I think we should just add a reference to that policy underneath the legal references.
Could I make a suggestion?
Sure.
Could we, if we're going to be explicit about acknowledgement that someone may have a condition and a prescription, we don't want to misconstrue it in either place, so I think we should almost use the same language in both places as far as that if someone is under the influence, I
Yeah.
mean, one, the item still can't be here.
Right.
Two, they cannot be under the influence to the point where it's impacting their ability to perform their job.
Yeah.
I would just do it,
Just reiterate it.
just make it explicit in both places if we're going to do it, one or the other.
Yep, I think that makes sense.
When I read this, I mean, I see we're trying to update with, so in the purpose, it refers to a particular brand. Do we need to refer to the brand
Jewel?
or Jewel? I mean, I don't know anything about these products, so.
I don't know that much. Is Jewel
that-
like its own thing, or is it a brand? I thought it was a thing. Somebody asked the vape shops that are in Havertown.
We're gonna, just,
I don't, I actually
Speak of
don't.
Google,
I know.
see what it says there.
but when I read this, it reads, it refers to tobacco quite a bit, but then it appears to eliminate any device that delivers, any electronic device that delivers anything that's in inhaled form. Is that, like tobacco products number 2, the definition, any electronic device that delivers nicotine or another substance to a person inhaling from the device?
Controlled substance?
Well,
I'm just saying, should we add
are we,
controlled
is the
substance?
intent of this policy to, I mean, I don't know what electronic devices are out there, but,
Or another tobacco substance? You think you're just trying to like keep it streamlined to tobacco?
I don't know. I don't know enough about that.
I know.
So, Dr. Sutton, I think that is included in the Pennsylvania code.
What's included, I'm sorry?
That, I think that the electronic device,
Okay. So, like an inhaler is not, like a asthma inhaler doesn't count because it's not electronic? I'm just trying to understand the definition.
I don't think the intent is, so any electronic device, so the electronic device reference is taken directly out of, actually, the criminal code and in Title 18.
Okay.
So, similar to the homework assignment I have on the research for the different levels with the driver testing, I'm hesitant to modify that at all,
Oh,
just
yeah.
given how, I think more or less, and again, Dr. Romanos can speak to the practice, but I think more or less there's a general blanket prohibition of a certain type of item, and then it's on a case-by-case analysis if that specific item comes up.
We have a policy on inhalers, don't we?
We do, but this also says another substance, we wouldn't consider,
Yeah, it's under tobacco products definition, but it says
Yeah.
any other substance.
no, but I mean, I don't think we would, yeah, I don't think we would consider inhaler to fall under
Right.
another substance.
I just want to be sure we're not, if it's not overly broad, that I mean, I don't know what electronic device, I mean, I guess we could evaluate that on a case-by-case basis. Okay.
And I think that the policy with inhalers is also with EpiPens, and we went over that not that long ago. So we do have a whole policy around inhalers, yeah.
Okay.
I think the analysis is kind of looking at this in totality and looking at everything.
Yeah.
Working around that potential gray area. It all really reflects on, the kind of cliche, typical vape situation, e-cigarette situation. So,
And I just had a question on number 1, the definition of tobacco products, number 1 at the end. What is snus? Is it a typo?
Snuff?
Snuff and snus.
Snus.
I think that's a type of tobacco substance.
So we're ending
This
at
is
snuff?
also for Google.
I'm Googling right
Somebody,
on it.
Smokeless tobacco.
Clearly, none of us have touched tobacco in a long time.
Smokeless,
Oh, it is something.
smokeless
It's
tobacco.
Smokeless tobacco from Sweden.
Okay.
From Sweden.
Learn something new every day.
Wow, it's
Right.
exotic.
It can be snorted.
Okay,
All right.
it's gonna stay in.
Okay.
Okay, so you're gonna look into whether we can add like a qualifier for tobacco. If not, it's fine.
I think we can add a qualifier that would say
Other-
medical, medically prescribed inhalers shall not be this shall not include medically prescribed inhalers or something of the like, something to that
You could put it
effect.
in number 5. So for the purposes of this policy, tobacco product encompasses not only tobacco, but also vaping products. Like this policy is not intended to include inhalers or something like that.
Prescribed.
And then reference the policy that it does. This policy. So there's a couple revisions on this one. Do we think it can move for a first reading?
By the,
How much homework do you have?
Yeah, there's not that much on this one.
it's an interesting time of year, Dr. Rishi. No, it's by the
It was the 5th.
The
I
5th?
think.
Oh, we'll get it done.
The 5th, so you would need it the Friday before.
Yeah.
So that's not a problem for this
Okay.
one. We can move this one.
We're gonna move forward on that one. Okay. The next policy is, the AR on it.
Guess we should
So we're
look
not,
at
this is
that.
not a policy, this is the AR. But I didn't have any comments on this one.
This is one Justin is still going to be looking at because it has the reference to students.
Yes, okay, that makes sense.
So should we
Yeah, it
wait
does.
to
In
bring-
procedure, this has students again. Student possession. Yeah, this is so funny.
Yeah, it's a lot for that students.
Okay. So should we wait on both of these
Yeah.
until that's revised or just?
It's up to you. It's not going to, I mean, I shouldn't say it's not going to change that much. The changes are going to be changes that you're all going to anticipate. I mean, there's still
Okay.
going to be an investigatory procedure. There's still going to be analysis as to whether it violates board policy. But it's going, instead of like a reference to a student code of conduct, it's going to be referencing personnel policies.
Okay.
So
I would imagine this whole paragraph, students who violate this policy, that's just all gonna be removed.
generally speaking, it is.
Okay.
The procedure part, it references parent, guardian will be notified of the student's offense.
Yeah, this whole section on procedure is about
all about
students, so
students.
that whole thing is gonna come out.
Yes.
Okay.
Code of student conduct, parental newsletters,
Okay.
school counselors, there's lots of,
I think it's gonna be a short AR.
It is. It is.
Okay, I think we can come forward.
And we'll let Dr. Rishi, like if it becomes one of these scenarios where after further review, it really is just maybe 5 to 10 bullets in a guidelines, maybe we just move the guidelines back into the
policy.
itself.
I was thinking the same thing. That's fine. Okay. The next policy is 324, to propose new consolidated policy on personnel files. And it's formerly policies 324, 424, and 524. There's a couple of the old ones listed first.
Why do I feel like 324? Is that what you said?
Yeah, 324.
Did we talk about, am I on the wrong one?
Well, no.
324, right?
Yeah, but this is, you can go down.
I only mentioned that because I thought that we talked about retention.
We have a records
We
retention
have a
policy,
records,
and
yes.
that was
Okay.
gonna be my
Yes.
comment.
Okay. I was like,
So,
I remember
yes,
this.
it's in the 800s,
Yeah.
I think.
It is.
Yeah. So I would say.
The destruction part,
Yes.
Dr. Ramones and I talked about that on Monday as well.
I should be included in these discussions. No,
We're gonna strike that.
oh, okay.
Okay.
Which part? Because I think, if we're gonna strike it, that's fine, but my comment was, it says personnel files shall be reviewed at intervals established by the district, and material no longer required shall be destroyed, and I would just add in accordance with the district's record retention policy. But if you just wanna strike the whole thing, it's fine.
Here's the, kind of the gist of the conversation we had, which was, while we have this records retention policy and certain items might clearly fall into categories that are at expiration, when it comes to something that's already being maintained in an employee's personnel file, it's better safe than sorry.
Okay.
And it's better to just maintain it there.
I think when the policy on
It's like
records
6
retention,
years- It's 6 years after they leave or something, Jim?
Yeah.
yeah,
Like,
6 years, when looking at the retention policy. And we talked about there would be a concern too, that we do have people that reach out to us that might
Yeah.
have been out for a long time and, we have to go look at something. So that would just be a concern of just going through and start.
I think in our records retention policies, that we didn't make it mandatory, right? We said the records may be destroyed. Is it mandatory that they have to be destroyed?
I'd have to go back and take a look at that.
Okay, well, if that's the case, then we should take a look.
We can double check that.
I was thinking that it was mandatory because my question was gonna be, I wanna make sure that we're consistent, that we're not saying we're gonna destroy something here, but we're gonna keep it here. So if we could just align with both with this policy and the retention.
Yeah, and I think this is kind of one of those gray areas when you're having the conceptual discussion about the records retention policy. Typically, if there's something, and for whatever reason, my mind keeps going to like a litigation item or, potential, like a workers' comp injury or something like that comes up, it's really gonna fall into one category that not, generally speaking, may not be a part of somebody's personnel file, depending on, if it's like one of those two items. The workers' comp will be in the medical, and that would, in that instance, would fall into that category of, oh, well, this is a litigation involving an employee, but it's really, this is a litigation file that should be destroyed in accordance with the litigation timeline. Because, and in that instance, it's not being maintained in an employee's personnel file. So, but when we get into this kind of like guessing game, and we don't want to overcomplicate it either. So I think I would say the easiest thing is we leave items in personnel files until the 6-year mark after the employee has left, and then add the flexibility to the records retention policy rather than making it more stringent, because I think that's where we could potentially get ourselves in more trouble.
Yeah, I agree.
If we're destroying things, I think you'd rather have the flexibility to maintain it a little bit longer.
Okay. I think it's fine to strike this in this,
Okay.
new policy, and then if you want to take a look at our records retention policy, and if it looks too stringent, I didn't think we made it mandatory, but maybe we did. We got really excited about destruction of
I
documents.
just remember us talking about it a lot.
Yeah, I know, I think we did. Well, you know what, it was also a new policy. We
That's
had never
true.
had it before, so I think we looked at a lot of samples on
We
that
did.
one, right?
Mhm.
So, okay.
All it says is that in the records retention policy, the district shall make a good faith effort to periodically and systematically review and destroy records as contemplated in the attachment, and there's a retention schedule.
Okay. Is
Yeah.
that, did we look at the schedule? I wonder if that's where it is, though.
Oh, schedule, let's see.
Well, that's a reasonable effort, that's fine. Okay, I'm fine with that language. I don't think that that is
I
like.
think it's fine, and we can
Yeah.
just strike that.
Strike this
whole
from this
sentence.
policy. Yeah, I agree.
And then everything else that we added are current practices of the Human Resources Office now. Things like maintaining the separation of medical information from the personnel file, that's an ADA compliance issue. Maintaining the background clearances and related documents, something that the Human Resources Office already does. We just added it to the policy itself because it hasn't been updated in so long. Things like that.
I didn't have any other comments on this one.
I don't have any comments.
Right, we'll move this one forward. Go back. Okay. We'll move on to gifts. This is a proposed new policy on gifts, formerly two separate but identical policies, 322 and 422. And I have a lot of questions about this one and the AR, mainly pertaining to, do we want to anger all of the PTOs?
Yeah, I was thinking like this is.
Well, it's an existing.
I know, well, but does the existing policy make it so that it's restricted to administrative staff? Because that's how I read the change, that the change, it goes from administrative staff to district staff. And I think that those are two different types of people.
Well, 322 and 422.
And just for clarification, is this a policy that, it's a new consolidated policy? This is something that it's common practice to have?
Yes.
Even though it's not,
And actually, the current PSBA recommended language is that it's applicable to all staff.
And 422 is our for professional.
For professionals.
Yeah.
I guess like,
I mean,
this
whoever was
sentence
new
to me,
teachers every year.
this sentence to me is insane. Okay? In accordance with the intent of this policy, gifts of an especially sentimental nature of nominal value, such as Valentines made by students, cookies, and other tokens of this nature, should not be encouraged. And under no circumstances shall they be solicited by an employee. Fine, don't solicit them, but my kid can't make her teacher a Valentine?
I'm not saying, yeah, they can't make it. I know what you're.
yeah, that's why I come back to, is this a policy that we actually need?
So
It
the,
is.
Right. And if we do need to have it, then I think we need to,
Let's be
no
honest.
one's following this.
well, that's the other thing too, is
Is that language in the AR? I'm
It's
sorry.
in the AR.
it's
Yeah.
15
And
years
I
old.
literally, I'm just like,
Yeah.
is this real?
So it's 15 years old and it is carried over from,
Yeah.
2010.
I think we need to revise this and
Completely.
what our actual practice is, but also what we want the policy to be. Because I don't think that we want the policy to be that children can't give their teachers Valentines, right? And at first I was like, well, maybe that was a typo. But then, like, the rest of it is, no, it's not a typo. You actually don't want them to give them Valentines. And I understand some of the purpose behind this was that, some people can't afford things and some people can't contribute. And I certainly think that the way that our PTOs do it is that it doesn't feel like you need to, or that you need to give a certain amount, because in my experience, the PTO, the homeroom parent, they collect, and it doesn't say who gave money, it just says from the class, right? And so, yeah, I think we need to take a look at this and see what we actually want the policy to be, because I don't think that this, as it stands, is what the board, or at least what the general feeling in the district is.
No, I'm not even comfortable with the first sentence saying it's an undesirable practice. I really think that I would like for us to, line by line.
Yeah, I think that there was some good language in here that, we don't want it to make it seem like a student is going to be treated more favorably than than
That's
another.
fair, yeah.
Your quid pro quos and appearance of impropriety.
That's what we actually want to
Those are
prevent.
those are the two things.
And I think, like,
That's it.
the shaming piece, right, where it's like some people can't afford to give gifts, and that shouldn't, like, so I think we need to have something in here, not only quid pro quo, but also if you're not participating, that doesn't count against you. Do you know what I mean? Sort of like going both ways.
And I think the only other thing to think about how you want to articulate this within the policy is a lot of why these policies exist is to put the staff on notice that sometimes they do receive things and to get them in the habit of sharing that information with other people. So
Yeah.
in case they don't realize that a quid pro quo is being offered.
That's a really good point.
So
That's a really good
there's
point.
kind of
Yeah.
It's one of the policies that's included in our new teacher induction.
Yeah.
so.
I think what really threw me was the Valentine, the
Yeah,
personally
sure.
made, the sentimental Valentines
Sure.
made by like a 6-year-old.
We didn't
It's not-
write that, by the way. That was
No, I know
carried
it
from
was
2010.
here. I know that it was here. But that's not a quid pro quo.
My kids gave their teachers Valentines this year, I'm just saying.
That's not a because I'm the one who does this policy. So, like, this
one's in-
should not be encouraged. When I talk with teachers about it, I'm always like, you're not talking a lot about the gifts
Yeah.
and what children what you are receiving from the kids, but I can see where.
I guess, yeah, I agree with the sentiment. I just think we need to completely rework the policy and the AR.
I agree. And, whether it's a collective PTO or the homeroom parent or the students, they enjoy
That's
that.
different. Yeah,
Yeah.
I think that's
But I
different.
don't want to take it away from, even if they didn't bring something, maybe they're going to write their teacher's name, maybe they're going to be the one to carry it over. I think that we should continue to support that practice within reason, while also recognizing that we don't want anyone to be left out or anyone to expect something different, or et cetera, et cetera.
And I think it's a really good point that, there is somewhat of a fine line between, receiving a gift, having end of year gift, and then, improprietary reason that someone's giving you this. You'd be like, oh, you know, take a better look at Susan's
Yeah.
right exam or
Yeah, how about that
something.
science project?
Yeah, exactly. I mean, but certainly, I
Do
do.
this again.
Or even like, well, you know, I gave you that gift. I'm
Right.
surprised to see Susan's grades or anything like that. Making sure the teacher understands
Yeah.
this is going down the wrong alley. I should report this. Yeah. So I really do understand
Yeah, that's
the
for that.
purpose behind this, but it's just it comes off as really harsh,
Yeah.
and I think people would be surprised that this is what it says.
And so maybe if we, I think if we start with the purpose and really highlight some of the points that you talked about,
Yeah.
that would start us off, I feel like, in the right way. I think we just start off like, no gifts. And then, and then we don't, no one's listening anymore
Bah
for us to
humbug.
be able to explain ourselves.
Right.
Well, I think the last sentence in the AR, under guideline, gifts to school, it says no, it actually is pretty good. No employee shall accept from any person, whether directly or indirectly, you know, et cetera.
Okay, where are you? Sorry.
It's the last sentence under gifts to school personnel, your guidelines.
Yeah.
Okay, we're in the AR, got it.
Right.
Sorry, yeah, we should. It said, which creates the appearance that is offered with the intent to influence the employee.
Yeah. I
So
think,
that kind of says what the intent of,
Yeah, that's it.
I think that's right. I think it either which does have the intent to influence or creates the appearance, right? So I think it needs to be both. Because either the intent, whether the intent is there or not, or it just is that creating the appearance of the intent. You know, I think those are both really important. But I do think that might even be a good place to start with the purpose, right?
I think so.
I agree.
So would that go into the policy, the actual under purpose?
I think so. I think like
Purpose.
what Tanya said, we should be really clear why we're having this policy.
Purpose board. Oh,
Because I agree. I think
see,
someone
yeah.
reads this first sentence there that says an undesirable practice, like, okay, well, this policy is a joke.
Right.
And like, why should we read it, the rest of it, right?
Yeah.
So I think we need to be specifically clear. I think the definitions are fine. And the delegation of responsibility, so that's fine.
So shift that sentence from the AR to the
To the
purpose.
purpose.
And then we'll work on the AR,
Yeah, work on the AR, right? Because even, like this one, the first paragraph seems also fine, you know? It can, to some persons under certain circumstances, place the person accepting such gifts or favors in a situation where a return obligation might be indicated. You know, I think all of that is fair. But then it's like when it gets to be discouraged, I think that's when the language becomes a little bit, not specific enough.
So it's more, you're looking for more of a be cognizant of rather
What they
than
can do.
Right,
discourage. Okay.
right.
And then for clarification, I am back to the AR. Is this the common practice that an employee must inform their immediate supervisor regarding the gift? Is that what happens? So when they get the end of the year gift, are they all going to the principal and saying, I received X, Y, and Z?
I
So
would just ask it.
Right, I just think that consistent
I
with
think
all
if
the other
some get-
policies, we should,
If they get
It's coming
something
back.
that is,
they had a car, we should go
Well-
report.
Yeah, right. But honestly,
If they get something that's
But even-
this is,
an exorbitant amount, like as a former principal, you know, they
Well-
weren't coming to me and George, I got a $5 gift card,
Okay.
$5 or anything like that. But if, you know, hey, the kid came up to me at an elementary, gave me like $100 in cash.
yeah.
Nordstrom.
I
Yeah,
think-
like,
right,
so
I mean,
that's when they would bring it to my attention.
Okay.
As the
I
building.
think that it can even be a lower amount when it's coming from an individual. Do you know what I mean? Like, so I think like it's almost like an above a nominal amount. Because I think the class gift
Because
It
it's a
says something
class.
completely
Yes.
different.
And it's a-
You know what I
it's
mean?
a
Like a
class
class
gift
gift
card.
is
But I
not
think-
a quid pro
yeah.
quo.
Right.
But I think if that exact same gift was given by one person, one family, that's when you're like, whoa, you know, this is too much, like, this is inappropriate. And so I don't know how to like capture that.
That's the difficult part. of it.
Yeah, I know, it's really difficult, but I think that we should try and make those distinctions, because like I said, you know, I think it makes really good sense for the staff to be on notice that they should be reporting gifts. But I think that we should maybe even give examples of what a reportable gift is and
Yeah.
what isn't.
That's helpful. Give the examples.
Yeah.
And it's different, they're not getting class gifts at the secondary level.
Right.
So I feel like this is really like elementary.
This is,
they're-
yeah, the
they're
elementary is
getting-
getting like class gifts, but yeah, a
If
teacher.
they're getting something in the middle or the high school.
That's
it's an
different.
Individual.
That's true.
Yeah, right. And I'm sure that still happens. I think absolutely, you know, end of year gifts or anything, you know, I know some people's love language is giving gifts, you know, but I mean, but really there are some people who like, that's what they really pride themselves in, is getting a gift for someone, and that shows their appreciation. And that doesn't necessarily mean there's a quid pro quo attached. But I do think that teachers, we should give examples in the AR, like what types of things are a reportable gift. Yeah, no, I think we need some more time with this one. Since we did ask for like a complete rewrite. I think.
Thing. Just
Yeah.
come back with the title, Justin.
Yeah, the title can stay.
Okay.
Okay, more about gifts in a different way. We're gonna look at policy 702, which is an existing policy on gifts, grants, and donations.
And this is made to the district.
To the district. Right, this one is made to the district. So right in the purpose, I had some comments. The board recognizes that individuals, businesses, and organizations in the community may wish to contribute additional supplies or equipment to enhance or extend the instructional programs. I was thinking we should also include just other contributions, because I think we also sometimes just receive money. Right? I mean, I'm just thinking like, I think it was Acme or gave us, you know, just a check, right? And so I think that we should include, it's not just supplies or equipment, but this applies to just any sort of contribution.
So,
Yeah.
question about the right to refuse. So the board reserves the right to refuse accepting a gift which does not contribute toward the achievement of the goals. So if someone, let's just go back to Acme for example, here's a check for X amount of $1,000. Please use this as you see fit. Is that covered, or does the gift giver have to identify?
I think we have in here, it was, there was something, okay, so on the next page,
Okay.
it says the district shall make, well, you said every effort, and I think it should be reasonable effort, but the district, let's call it reasonable. The district shall make a reasonable effort to honor the intent of the donor in the use of the gift, but it reserves the right to utilize the gift in the best interest of the district educational program.
Okay, so that's covered. So then what would
Yeah.
be an example of something that be refused?
I think it was like inappropriate. I don't know
So,
if they do, but they
I-
might try.
I've seen book donations be refused.
Okay, okay.
Yeah.
So I think then we need to define achievement of the goals or give an example, whether it's inappropriate, whether it's because,
So I put, this one was bothering me too, and I
Okay.
altered it to just say, in the subjective view of the board. To just basically give the board the, subjective right to refuse it based on their view of the goals that they created.
Which in their view does not, yeah.
Yeah, because I think it does need a little bit more, like, well, so who says that it's not going to contribute to the achievement? The book example, I think it
Right.
does. But at the end of the day, it's the board accepting the gift. And so it's the board reserves the right to refuse the gift. So I think it should just be in the subjective view of the board, whether it meets the goals.
so I guess I come back to the book example, right? If someone gives a set of books and there are a diverse set of opinions regarding books and materials. And it could be an educational book, and it could be even linked to a certain section of the curriculum. That would mean that we could potentially be in a roll call vote, if you will, over a book or gift. And I feel like we are going down a slippery slope.
Yeah, but I think if you think about it not like a gift, like, I can't think of something like truly inappropriate, but like, there could be something that actually is very, like a gun.
I think we can agree on a gun, right?
Yeah, but that's my point. Like, but someone else who's saying, I think a gun is good for students, and I mean, whatever it may be, but like there, someone.
Can always be an opposing.
There can always be an
opposing.
always be an opposing view, and I just think at the end of the day, the board is going to want the right to refuse it on their own subjective view and not be challenged by their policy.
Yeah.
The board is the only, they're the elected members of the community, like they're the authority on it.
Yeah, I think the board has to have blanket right to refuse.
Yeah. In their subjective
good.
view. And so, yeah, maybe it will come down to a roll call vote at some point, but I think that that's fair. The district is accepting this. I mean, just like the budget, like we're going to decide what we spend money on, and that's up to the board. I think it's the same thing for gifts.
You can vote yes or no.
You vote yes or no. Yeah, right. And you can vote yes or no on the budget too.
Okay. So as long as I feel like we're clear that what that would mean,
I think this could be simplified, because I think the problem is, what you're getting at, Latanya, is like, what does it mean achievement of the goals of the district or adversely affect the district? Maybe we could just say the board reserves the right to refuse to accept any gift which in their view does not contribute. Let's see.
see, here's my thing though.
How about just the board has the right to?
The right to refuse any gift, period,
Yeah.
full
Period.
stop.
Yeah.
There we go, okay.
Yeah.
Yeah. Refuse to accept any gift, period. Yeah, why give a reason?
Right.
Again, because if it's just it's up to the board. Okay.
I think ultimately different boards are gonna have different views,
Yeah, exactly.
so,
But at the end of the day, the community elects the board.
right.
Speaking of quid pro quo and appearance of impropriety, I thought it would be good to add something like that to, the acceptance of the gift shall be subject to the following criteria. So I was thinking to add, number 8 along those lines. And I already made my note about reasonable efforts, not every efforts. A couple paragraphs after the reasonable efforts, it says the superintendent shall publicly report to the board all gifts to the district accepted on behalf of the board. And so I guess my question is, does that imply that the board does not vote on accepting gifts? How would that work?
Not unless that's just when you reporting, doing your superintendent's
I would
report.
not recommend it.
No, I think the board needs to vote on
Yeah.
accepting gifts.
No, I agree, but I mean, is that what this is meaning? That that's when you would publicly report it, when, like, during your superintendent's report, but then note, at the end, the board
Being
still,
voted on
yeah.
it.
Mhm.
Yeah,
I don't know, that just seems weird.
That does.
yeah.
District acceptance.
I think
on behalf of the
Yeah, on
board.
behalf of the, no, I don't think that,
It's everything after, or starting with accepted becomes problem, because.
Yeah, I think that we just need to strike
Oh,
that
yes,
sentence. Because, yeah, accepted on behalf,
Okay.
I don't think that the district
Sure.
I don't think that the superintendent should be accepting gifts on behalf of the board.
So just say the superintendent shall publicly report to the board all gifts to the district.
I think we just strike the whole sentence.
Because it'll be on a board agenda.
Yeah, because we have to vote on it.
Yes. I agree.
Is this
Strike the
only-
sentence.
I think what you might want to do somewhere along the line is look at a threshold.
Yeah,
You know, I mean, like we had the one that was $20.
yeah. And maybe
Those are
that's,
great
maybe we keep it
donations to
in and we say something like that. You know, that maybe the superintendent
Oh, I see.
Can accept donations under $100 or something on
Do you-
behalf of the board.
Do you
And
want to add like subsequent ratification language though? So if for some reason, like you're just speaking about an issue comes up later,
Oh, yeah. Okay.
so
Then
just,
I would just leave it on.
Yeah.
I would just leave that straight
Okay.
out and put
And
everything
just-
on. I was just trying to eliminate, like, we had very appreciative of the donation that we received and the purpose for which it was received. But a question came up from one of our board members, do we have to approve every single
gift, yeah. I think we do. I think that's probably just the best practice.
it is.
Yeah.
I agree. Probably because we don't want to get ourselves to a situation a gift less than $100 could also be
It's not as
inappropriate.
worthy
A quid,
as something, yeah.
and it could be a quid pro, yeah,
Yeah.
that could be like a quid pro quo type thing. It'd be like, well, I know you don't have to tell the board about this one. Here's a $50. I don't know. I don't know what people are getting about this. $99, yeah.
Yeah.
Right. So no, I
We'll
think,
just
I
leave
think,
it alone.
I think
Do with
just
this
leave
as
it.
you may.
Who knows who's doing this? Okay. And then, is there a difference between a gratuity and a donation? Like, what is a gratuity in this? Are we tipping?
Tip.
You know what, is that weird to you? I don't, that
It
was
is.
weird that it was included to me.
This is just that really old language.
Okay,
yeah.
we're just gonna take out gratuity. That doesn't make any sense. Okay, sorry. And those are all my comments.
And just, sorry to come back to this. So are we leaving that, the publicly report, or are we just
No.
striking? We're striking it.
Striking
Okay, we're
it.
leaving, okay, was leaving the strikeout.
Leaving the strikeout, yes, correct.
Got it.
Wait, did we talk about class gifts?
No, we haven't talked about that yet.
Okay. Why is, let me read it again. So like if a class, I don't know, donated something to the district, is that what we're referring to here?
Yeah, they do that every year, right?
Like a swing
Yeah, so
set
there's
or a?
scoreboards
Okay,
over at the
got
high
it,
school
okay.
that were donated by, I think, there were like 3 different classes.
Okay.
The monies that they had left at the end, they just pulled them together.
I think we still vote on those too, don't we?
Mhm.
Yeah,
Yeah.
I was gonna say, that's
It
not,
came before you.
yeah,
Yeah.
okay. Yeah, those are always fun to see, what the creative
I have to say
ideas
that,
that they come up with.
yeah, this language, like, is, it feels like it's from 1950.
I know, yeah, like, how long ago was 2010, guys, that this was the language that people were
But carefully consider the proposed gift, including the practicability of the project, especially if it's a matter of yeah, okay.
That's just a lot of
Let it run on.
legalese, to
Just
be
rephrase it, just
honest.
clean it up.
Yeah. I mean, yeah, there's not, I don't have any problem with it, it's just,
We'll look at it and see what we
Odds
can
and-
do to maybe put a period or two in there.
Okay. Yeah. Okay. Any other comments on this one? I'm gonna move that one forward. Okay, last one of the night. Perfect timing here. Hopefully I didn't say that too soon. This one is an existing policy. It's, policy 828 on fraud. I had a comment, right?
I think
So it's actually.
Oh, it's new?
New, yeah, so the background of this one is, this was a request from Mr. Testa's office that it be added. The issue came up in some compliance monitoring so as a best practice.
Okay, for us to have the policy?
Yes.
Yeah, that makes sense. Okay, so I was confused then, because there's like strikeouts in it and
Yeah.
everything.
that's
So this was originally a template from PSBA that we uploaded. He then reviewed
Okay,
and that's
Yeah, it doesn't exist as a permit.
Okay.
how we got to here.
So I have an addition for the authority. The last sentence says, "The board is entrusted with public funds and no one connected with the district shall do anything to erode that trust." I would say betray or erode that trust.
Under the definitions for number 2, why was that striked out?
I think it's, my understanding is that because it was covered by document. So it seems
Covered by document.
repetitive. Document or account.
And then 9 was just moved into 10.
Yeah, just consolidating.
Okay. So, just to be clear though, a check, a bank draft, or other financial document, yes, but a check or a bank draft is covered by a document?
Or account.
We can, I mean,
It said it's repetitive, it says the same exact thing.
Okay.
we can add it back in. I mean, it's not illegal.
No, yeah. I don't have any comments until the confidentiality section, so.
I just, under reporting, I'm kind of grappling with kind of whistleblower, and protections. It does say that employees who bring forward a good faith concern or suspicion shall not be retaliated against. Is that, I don't know if there's any more explicit anti-retaliation.
It also says those who do retaliate against an employee shall be subject to disciplinary action.
Right, okay.
Up to and including termination?
Sure.
We have it in other policies.
Yeah, that works, okay.
You said you have a question about something else?
Yeah, confidentiality. So I just have a comment. The last sentence in confidentiality reads, "Results of an investigation shall not be disclosed to or discussed with anyone other than those individuals with a legitimate need to know until the results are made public." And then I would just say, other than those individuals with a legitimate need to know, unless or until the results are made intentionally public. Like intentionally made public, like it's not a leak situation.
Well, this could also be read by someone to expect something to be made
To be
public.
made, that's why I
And it-
added
and
the
it- and it
unless,
may not-
right?
it may
Unless or
not.
until, so, right, I think that gives us the opportunity to never make it public. And I think we want to be the ones controlling that.
Do we, earlier on in the sentence, do we need to just explicitly say that the results of an investigation shall remain confidential? I just feel like it's not
Yeah.
completely clear
Yeah,
that.
that should be the first sentence. I agree.
Sure.
We, check signers are approved annually by the board? I don't remember.
Yeah.
Are?
I think that's actually in another policy too.
Oh, okay. Who do we approve? I don't remember.
Tony?
Okay,
Tony's approved, I'm approved.
Yeah, I think Latanya's approved, yeah.
okay. Check shall have at least.
But I do have a question about deposit of funds. So it says all checks and cash received by the district must be deposited within 24, 48 hours. There's no exceptions there. Are there ever exceptions to that? Like it never happens outside that period?
I don't think he wants exceptions.
No, I don't think we do either,
No, I
but,
don't think Tony wants exceptions.
yeah, okay. I just wanted to make sure that like, that this was reflecting, you know, real life. Yeah, that's fine with me. I think that's for the best.
So I mean, to that point, that would mean like if something is received Friday afternoon and Monday happens to be Memorial Day. Business days. Okay, so should we add
Yeah,
24
so
to
this
48
says, yeah, see,
business days?
this doesn't say business days.
Yeah.
So then should we make it 1 to 2 business days?
Yeah, I think that's,
Yeah.
That makes sense to me.
So that's what I was thinking, like, what if somebody drops it off and there's a snowstorm?
right.
You know, like they're
Or it's
giving you a check.
4:55, FedEx just came, you wouldn't
Yeah.
like run that over to the bank.
Yeah, okay, I like 1 to 2 business days.
And all checks and cash, that covers all forms of payment? It might be,
Wire would just go directly into it, so it doesn't have to be
Right, but-
deposited.
we don't have any, I guess, PayPal or,
We have, what is it, Trish, do you remember? It's like that.
Right, it's one form, it's a newer system, but it is automatically.
okay, it's automatic, okay. But the policy doesn't say anything about electronic, that's,
No, there's other policies about how to pay.
oh wait, it does say physical and electronics.
Those are all my
Good.
comments. I think we'll move that one forward.
We can move that forward.
Okay, so I have quite a bit, then we're gonna move forward. That's great. There's no other content for our meeting. There's no notifications or anything. And, sadly, there's no one else here in the boardroom with
I
us.
did have a general question, I've been on the board now over a year, but, how many, so reviewing policies, do you have a system or how?
We have a policy on how to review policies, actually.
Okay. Is that one of the
I think it's in the 100s.
100? Okay.
And I can paraphrase it. It's basically that we have our policies on an audit for a 5-year cycle to try
do remember that.
to try and touch all of our policies every 5 years, but it gives us the ability to go through policies out of order or otherwise if we've reviewed them recently because there have been changes.
Or like
Okay.
Tony wanted something because of
Yeah.
an audit
Right.
review.
Right.
But do we have a schedule or do we have
I think we're just going through them by section.
sections?
Generally. So we started with 100, yeah, the zeros, and the 800, 900s, and then I think, so,
We've done all the sixes.
All the sixes
all the
we've
sixes,
done.
okay, yeah, so we've been doing them in chunks.
Okay.
And then I think we waited to do the 3, 4, and 5s because there's so many
You
of
could
them.
consolidate
Yeah,
a
and we're
lot of them.
consolidating.
Right, okay. So we did skip around it. We did the
We
zeros.
did skip around, I think intentionally, to try and get to, there were some very old policies, and I
Right.
think the ones that were the most visible to the public, we wanted to do first, which was those zeros, 100s, and like the 900s.
Okay. The reason I ask is going to PTOs and interacting with some of the community, they've raised some of the policies. And how would we do something out of order if, what?
I mean, I think things have come out of order by a lot of different ways. I think, I can't remember if we've done one because of the public, but I feel like we have. That something was just around the community and that we were, so.
Oh, we did the sustainability one.
The sustainability
That was
one,
new.
yeah, that one. Yeah, so I mean, I would say by suggestion, by anyone
Okay.
on the board or in the public, and if it's something that we feel like should be.
Okay. Yeah, I took some notes, so maybe I can forward my note,
And I think it's important also to note that, so while we do get suggestions from board members and community members about, can you review this policy? We have to be strategic with which policies that we review, because otherwise we would get a policy review
Right.
request all the time. And so
Yeah.
when those requests come, it typically goes to board leadership, so that's myself and Kristen. Antoinette's included as the committee chair, and of course Dr. Rushi, and that's a discussion that we have. So I
Okay.
don't want to misrepresent that someone can email a policy for us and it's going to be on the agenda.
Right.
That's not, sometimes we'll say this would be great, let's do it for the fall, or
Yeah.
let's wait and do this one instead because it'll be about this. There is an actual discussion and a plan for how the policies are on the agenda, even when we do go off of the course of it.
That's a really good point, especially because we get the policies here in a really, really good draft form, but you can tell even through the discussion tonight how much Justin and Tony worked on these policies, or Justin and George worked on these policies. And especially when there's policies that affect students, that affect our teachers, that goes through, I mean,
Yes.
dozens of levels of review before it comes to us. And so, I know when, several of our policies talking about, students, I mean, I think every single building principal looked at it, multiple, department heads. And so it was just, it really isn't just as simple as, well, we want to take a look at this policy. What we want to do is we want to look at the policies really deliberatively. And so make sure that when the committee is looking at the policy, all of these other reviews have already happened. So that we can take a look in sort of the form that is aligning with the district policy and practice, and is something that we understand, this is sort of what's already going on. What does the board now want to review about it?
One of the policies that's currently being reviewed is a suicide prevention policy, and there were changes that were made that we need to look at, but that has taken, we originally thought we'd have that for tonight for people to look at, but that has involved so many of our educators, our mental health providers, reviewing that. Joe McConney, looking, because he's part of the threat assessment training, and, just looking at all of that. So, to your point, it goes round and round.
There's a lot that goes into it.
Yeah, I was just mainly looking for how to provide feedback.
I think it's always, the community should always feel empowered to come and speak or write to us and with their suggestions. And I guess I want to tell anyone in the community as well that just because your suggestion isn't immediately acted upon doesn't mean that it's not under consideration or isn't going to be reviewed at a later time, but it just does have to go through so many channels that, it would be impossible, like Latanya said, for us to just be like, oh, well, someone wanted this, so we're just going to put it on.
Right.
There's a lot that goes into it on purpose, and I think for good reason.
Okay, thank you.
Adjourned.
Got that gavel now. Thank you.
There we go.